That's
All right,
great.
so I think we'll go ahead and get started. We have a few more that are coming, but we'll just kind of usher them in quietly when they get here. Thank you all so much for coming. It's so nice to have you all back, and we are so excited to have Justice Hart today speaking to us and telling us a little bit about current trends in the regulation of the provision of legal services to increase access to justice. And she did a great listening tour, and everybody really enjoyed that. I actually spoke to some people afterwards from like the YWCA and places like that, and they were really enthusiastic. So really looking forward. Thank you.
Thank you. Thank you for being here. I guess I'm being recorded. Thank you for being here on the recording. I'm really glad to be able to talk to you all about this topic. It's something I'm very passionate about. The listening tours that you just heard reference to, I just want to say a little bit about those. They're actually separate from the court, although central to a lot of what we're trying to do, or I'm trying to do at the court, we're trying to do, I think. So the Access to Justice Commission is a statewide entity. There are 20 commissioners. Well, there are a lot more than 20 commissioners. There are 20 appointed commissioners, and then a whole bunch of us who are hangers-on, who are ex officio and things like that. So, but we sort of looked around this spring and thought, or I guess really last fall, and thought, what can we be doing during COVID? Because in previous years we've done hearings where we've brought people together to talk about the need to increase support for access to justice and things like that. And we decided that it would be interesting to take advantage of the fact that we're all pretty Zoom literate and do a statewide tour over Zoom. So between March and the end of September, I think we did 42 meetings. We met with folks in every single judicial district to talk about, and the people we sort of tried to connect with and met with, we reached out to some people within the court system. So some judges who particularly we focused on judges who are doing evictions, judges who are doing family law, and then the chief judges in each district, and the court executives, which is sort of the non-judicial leadership in each district. And then we also reached out to service providers. So Colorado Legal Services attended and was really essential to every single one that we did, but also people who work with domestic violence survivors and people who work on language access and people who work with immigrant communities and the homeless and sort of anyone who we thought might represent people who were trying to access the justice system, to ask them what's working, what's not working, what are thoughts you have about what could be going better. We're going to be the commission is going to be producing a report about that by the end of this year. But it was a really fascinating opportunity to hear a fair amount of focus on COVID and what's working during COVID and not working during COVID, things that people really hope the courts will continue after COVID. But also a lot of things that predated and will post-date what I assume is an eventual end to a COVID-defined life, if not COVID itself. And it gave us a lot of ideas about things that we could be doing better in the courts. And so, again, it was separate. It's the commission, and the commission will be making recommendations and issuing a report. But because I was the sort of face of the commission for all of these meetings, so I attended all of them, and each week would bring back to my colleagues, we heard this really fascinating and frankly problematic thing in the 21st Judicial District, and we need to think about how we can address it. It really did give us a snapshot of the things that we in the branch could be doing better. So Chief Justice Boatwright just authorized the creation of a committee within the Judicial Department, which we're calling the Pathways to Access Committee. There are too many things called Access to Justice Commission Committee, so we thought we would try something else. Plus Chief Judge Susan Blanco up in Fort Collins turns out to be a very big Pac-Man fan, and she really liked the idea of the Pac-Man eating up the problems, and also of the idea that there are different pathways that we can create to make the system more effective. Language access is a pathway to access the system. Online pro se e-filing is a pathway to access the system. Plain language forms, another pathway to access the system. All things that we need to be working on. So I'm very excited about that committee because I think that the Chief Justice really recognizes the need to supercharge the work that we've been trying to do to make the system more accessible. I mention all of that because what this presentation is partly some of what's happening in Colorado, but more, I think, what is really an accelerating nationwide trend. And I think COVID has probably accelerated it even further, then also shifted it some in terms of what people are looking at. But ultimately, many states have recognized, as we have here, that we just can't keep going the way we are. It's not sustainable. It's not just at all. There are too many unrepresented litigants in the system. At this point in Colorado, just about 80% of the litigants in family law cases are unrepresented, and well over 50% of litigants in all civil cases are unrepresented. It's not fair to the litigants. Our system is too complicated, and we need to be working on some of the ways that people who remain unrepresented can have an easier time. Again, things like plain language forms and language access. But the truth is, there just are times when people need representation of some sort, that being unrepresented is not the right answer. States, these are the states that I know are actively considering or actively implementing reforms. There are actually more than this at this point, but I was scared to put some that I've now heard about. I wasn't able to confirm, and I didn't want to put something down that wasn't true. So you hear about, there's a network of people talking about this all over the country, and you hear, oh, someone told me that North Carolina is one of the ones I've heard recently, that North Carolina is doing something, but I wasn't able to find them. But there is a coalition of folks that meets over Zoom once a month from all different states to talk specifically about one of the reforms that I'm going to talk about today, which is licensed paraprofessionals. And that's where I would say the most real activity is happening right now. And so that's sort of where I get a lot of my information, is in joining these meetings with judges and state court administrators and lawyers from states all over the country. So I want to talk really briefly about non-lawyer navigators, and then I'm going to spend most of my time talking about the licensed paraprofessional proposals, and then a little bit about multidisciplinary practice, non-lawyer ownership, and technological service provision, all of which are things that states are in different stages of looking at. Non-lawyer navigators. There's a report, and I think Kyle is going to send out after this, I think with the CLE form, I provided a bunch of reports and things that you might find interesting. There's a 2019 report on non-lawyer navigators. It didn't even, by now this isn't even true. By now there are more than 23 programs, but the 2019 report, which was the most thorough report about non-lawyer navigator programs, looked at 23 programs in 15 different states and DC. About half were court supervised, so they weren't, those were volunteer programs. Actually, they're all volunteer programs. Half court supervised and half are run by nonprofits. And they provide a huge range of services. But the idea, so we have, as you may all know, we here in Colorado have our self-represented litigant coordinators, Sherlocks, and they can do a lot. They can provide legal information, but one of the things they cannot do is go into the courtroom. And one of the things that these programs recognize is that it's in the courtroom that often the most desperate help is needed. And we just we haven't had anyone to go into the courtroom with the litigants who are trying to get their problem solved in the courtroom. It's in the courtroom also that the problem becomes a problem for the courts, the judges. There are some judges who are incredibly talented at working with unrepresented litigants and helping them get through the process without advocating for them, helping them understand the basic things that they need to prove without proving it for them. Some judges feel like if they do any of that, they're advocating, and they therefore won't help at all. You can probably tell from my tone that I disagree with that, and I think that's very bad. But it's a challenge, because when you are alone in the courtroom without anyone to provide you emotional support or legal support or just explain what's happening, impossible for lots of people. So some of these programs, so as I say up here, 90% of them have referrals, legal and procedural information, and then assistance with forms and documents, somewhat like our Sherlocks, I think. And again, they didn't count our Sherlocks as navigators because they really aren't. 75% share information on available options, so they won't make the choice for someone, but they really will say you have several different paths that you could take, rather than just saying, here's some stuff to read, but actually being a little bit more, I'll say, directive. 35% provide court accompaniment. That doesn't mean advocating for a person in court. It means being there generally to answer questions and to provide emotional support. As I again say here, there are a variety of substantive areas. I think every state recognizes that domestic relations, family law is just too. I mean, our statistics of close to 80% are not unusual. Most jurisdictions have that level of lack of representation in family law. Housing, which really means evictions most of the time, is again, that's even higher. I think it's about 97% of defendants in eviction cases are unrepresented. And frankly, a lot of plaintiffs in eviction cases are unrepresented. So that's just an area of law where people are really struggling to figure out what's going on. So I think non-lawyer navigators are a really interesting idea. What's challenging about them is that they do tend to be volunteer programs. So here in Colorado, we have a couple of programs that we call navigator programs. In Adams County in Brighton, there's a program for eviction cases where both the landlord and the tenant are unrepresented. I don't know how many volunteers there are at the moment, but there have been as many as 3 or 5 who will come in and be available to sit down with both parties and essentially explain to both of them, to the plaintiff, it would be better for you if you could get the defendant to agree to leave voluntarily. You don't have to have a sheriff come out. That's going to take a certain amount of time. And you could probably have your tenant depart sooner if you could do it without an actual eviction order entering. And to the defendant, it would be better for you not to have an eviction on your records. So a good solution would be to, effectively sort of mediating, trying to get the parties to an agreement that might be better for both of them. That did continue during COVID in a remote way. I don't know whether it's picked up again in person now, actually. There was a similar program down, interestingly, in Trinidad, in the 3rd Judicial District, because there was a very dedicated Sherlock there who developed and was running the program. But Brighton and Trinidad highlight one of the challenges of navigator programs. Brighton has enough people, senior citizens, all of the volunteers are senior citizens, available to come in and volunteer their time, that they could run a program. And Trinidad had a person who was willing to take it on and really work. She was working half a job again, just on doing that, in addition to her regular job. And you need either a lot of people available to be volunteers or someone with that force of personality and dedication, and probably really both, to make a volunteer type program work. So to me, although it has potential to be an exciting solution, it's not a whole solution. And it has inherent limitations in that it requires anything that is volunteer requires people willing to volunteer. So licensed paraprofessionals. This has been a topic of conversation in the access to justice world for at least 10 years, more than 10 years, because Washington State licensed their limited license legal technicians starting in 2012, or they started the program in 2012, approved it in 2012. And at that time, we all sort of looked at them, we were like, is this going to work? Let's wait and see if this works before we start exploring whether anyone else should do it. I have some good friends in Washington who would be mad if they were listening to this, but I think this program was set up to fail. It was set up by the State Bar Association, so it was set up by people who started from the position of, this is going to take clients and jobs away from us, and we are very scared of it. And so it was developed with that mindset. The title, Limited Technicians, like nothing about it feels good. It feels bad. And because it was set up with sort of anxiety about eating into lawyers' bottom lines, it was set up with very, very high barriers to entrance, what have turned out to be almost insurmountable barriers to entrance. So they can work in family law, they can complete and file documents, and they can do navigation in courts, but they can't appear in court at all. In order to become a triple LT, which is what everyone calls them because it's such a long name, in order to become a triple LT, you have to get 45 credits of legal studies in a program that had to be run in one of the Washington State law schools. So one of the things that happened pretty quickly is the Washington State law schools figured out they couldn't come up with a sustainable model for even offering the specialized classes, because it was its own special set of classes. It wasn't, take some number of specific classes at the law school that are already offered. It was its own unique program. Then you have to do 3,000 hours of supervised legal work and pass 3 exams. It's a lot. The 45 credits of legal studies was effectively 2 years of legal studies, so 1 year shy of law school. Part of the idea of a licensed paraprofessional is that there could be lower costs to entry and therefore the potential for charging lower fees for legal advice. But there weren't very many lower barriers to entry in the triple LT model than in just the law school model. So from 2000, I think the first triple LTs were licensed in 2015. And because there was a change in personnel on the Washington State Supreme Court, last year the Washington State Supreme Court announced that they were sunsetting the program. Not even sunsetting, just canceling. People who had received their licenses could continue to practice. So there are, I want to say it's somewhere around 50-some triple LTs in Washington, and they can continue to do their work, but the program ended. So, but what's good is I think all of those of us who think that this could be an interesting solution or part of a solution for access to justice learned a lot from Washington State. We learned a lot about what not to do. We saw that one of the problems with the barriers to entrance is until there are enough people doing this, it's really not going to be a solution, and consumers won't really know about it. So having 50 or so triple LTs in the state of Washington it's not like the nurse practitioners we all know when we go to the doctor. It's not something that becomes common knowledge where consumers will understand, oh, I could go get this service. I don't need a doctor for this. A nurse practitioner will work. So when Utah, which was the next state to move forward with licensed paralegals, decided in 2019 to implement their program, and they called theirs licensed paralegal practitioners. They said, okay, we're going to try to remove, because these are people who are going to be permitted to provide legal advice. It's not like a Sherlock where you can provide legal information but not advice. We're talking about people who can provide legal advice in some areas. We can't have no barriers to entry, but we're going to try to minimize the barriers to entry. So in Utah, licensed paralegal practitioners can practice in family law, debt collection and eviction, so basically county civil in Colorado. They can complete documents, they can review documents, they can provide advice. They cannot appear in court. They are regulated by the Utah Supreme Court, and what you have to get there is a degree from a paralegal program. So we have lots of community colleges offer paralegal degrees, and then 1,500 hours of law-related experience, and then there is an exam. at this point, I think last time I checked, it started in 2019, and I think there were 20 licensed paralegal practitioners in Utah, which again, in a much shorter time. I mean, they're optimistic that that this will continue to grow. And importantly, I should mention, in both Washington and Utah, the triple LTs or the LPPs can practice without supervision by an attorney. So one of the big divisions when we look at states and what they're considering, some states say we want this, but you have to be supervised by an attorney. Some states say they can practice on their own. So Arizona just approved what they're calling legal paraprofessional. And I highlight that they all have different names because I think it's one of the things we need to fix. Again, certified registered nurse. We all know what a registered nurse is. You know what that is in Massachusetts. You know what that is in Colorado. There may actually be different licensing requirements, but you still know what it is. It draws to mind immediately a thing. But so far, no state, and Colorado's included, as you'll see on the next slide, no state has been able to agree with any other state on a name. So we have a lot of different names. But Arizona's legal paraprofessionals can do family law, they can do limited civil, they can do misdemeanors, they can do administrative law, which actually in every state now, non-lawyers can practice in administrative proceedings, but this is specified there. They can draft and complete forms and documents, they can give legal advice, and they can appear in court. So that's a big change, and it's a change that many people think is necessary to have this be successful. That one of the problems, again, is where people really need help is in that courtroom in front of the judge making arguments. And then they can negotiate. They have an certification through education, so they have a course you can take, but they also have the possibility of certification through experience. If you've been a paralegal for 25 years, doing family law as a paralegal, you don't need to go do the training and things like that. And there is an exam. So Colorado is also looking at this model. We have settled on licensed legal paraprofessionals. We had lots of debate, and I'll explain who the we is. Many of us wanted to choose either the Utah or the Arizona title just to try to get in the registered nurse sort of area. And the challenge was some people really were troubled by the word practitioner, that it makes you think attorney, and others felt really strongly that it needed to include licensed to make it clear that we were talking about that these really were people who are going to have a license. So you can't, I mean, I have to say, in the course of doing this work, which I've been doing now for some time, I did not realize that you could become a paralegal without getting any kind of a license or degree. I have always assumed that all paralegals had gotten some sort of license or degree from a paralegal program. But that's why we felt that it was important to say license there, so that it was distinguished from a smart person who a lawyer says, okay, you are now my paralegal. Because that, again, in terms of risk limitation, felt important. So in Colorado, and the Supreme Court approved, in concept, approved the creation of licensed legal paraprofessionals in June this year. So for about a year and a half, at the direction of the court, there was a committee that was putting together a proposal for licensed paraprofessionals in Colorado. It was a committee that included several family law judges, several family law practitioners, a paralegal, a family court facilitator, a couple of other lawyers who just care about these issues but have no idea what family law involves. And this committee met monthly. We started in February 2020, so we met once in person, and then we met monthly over the Zoom to sort of hash out could this look like in Colorado? Would the court be likely to approve? And so the proposal that the court approved in June is that LLPs in Colorado will be permitted to provide legal advice with or without attorney supervision in certain family law matters. And when I say certain family law matters, we've excluded, we have income caps and income and asset caps. And part of the reason for this is because when this first was proposed, was floated as an idea back in, it's either 2014 or 15. The Bar Association, the Colorado Bar Association, got extremely upset. And there was that immediate, we are going to lose clients, this is bad for lawyers, you can't do this to us, kind of pushback. I think fundamentally what's wrong with that analysis is that when you look at the 80% of unrepresented parties in courts, these are not parties who just didn't realize they could hire a lawyer. Some of them are people who don't want help at all. They think they can do it by themselves. But an awful lot of them are people who can't afford to hire lawyers at market rates. So we're not talking about a population that would be hiring lawyers if they weren't hiring licensed legal paraprofessionals. We're talking about people who will be going to court by themselves, or maybe will be hiring a licensed legal paraprofessional. And that I think trying to decrease anxiety about the potential for encroachment onto potential legal services by making that clear is both a PR thing, it's about the way we talk about it, but we also decided that it made sense to initially start with some asset and income limitations, because those are also likely to be less complicated cases. And so as we looked at the kinds of cases that licensed paraprofessionals could work on, we said we want to be sure they're the kinds of cases that won't end up heading into complicated ground where we really actually think that a significant amount of legal training could help ensure that you're providing good service in those cases. So there are a variety of limitations. No contested custody disputes. Again, the income limitations. No cases that involve things like hudros. There are certain kinds of challenges that we're going to carve out for now. For licensure, we said you must, and I realize the way I've written this slide, it's a little confusing. You could become licensed as a legal paraprofessional if you had a law degree, although I don't know why you would do that. I mean, yes, I do, if you haven't passed the bar for whatever reason. So if you had a law degree, a bachelor's plus a paralegal certificate, or an associate's or bachelor's in paralegal studies, any of those kinds of educational background will work. So again, we're looking at things that are available at schools already. We're not creating a new program. There will be an ethics class and a family law class that are being developed to be offered at several different community colleges, and 1,500 hours of substantive practice experience. We have a similar to Arizona, although we've sort of framed it slightly differently, but similar to Arizona, essentially a waiver if you can show a certain amount of experience, that you don't need to meet all of these requirements. So that's the basics of the program. Yes.
You don't think retired lawyers might be interested?
Oh, that's true too. Yes, that's a good idea. Yes, then they'll have a law degree, so they would fall into that category. So at the moment there are, I was involved in the meetings up to May of 2021. There are now subcommittees meeting to actually hammer out the details. There'll be a set of ethics rules, what the education program will actually look like, and which schools it will be offered at. And it's my understanding that they're going to try to get this back to us by the end of this year so that we can have people who will start going to school or applying for waiver next year. We shall see. it's been a really interesting process, and really actually a great process in terms of collaboration with the bar that 6 years ago almost had a nervous breakdown. We had lots of meetings with them to talk to particularly the family law section about what are the areas of cases that they think probably really someone with a license and some experience should be handling. So that was great. I want to just mention for like barely as, oops, what did I do? Can you see that?
Was on the
No
way.
problem.
Sorry, I had a trigger finger.
Oh, that's okay. Max don't like really small. Sorry.
I'm really sorry.
What?
Thank you. So the last thing I want to just talk about briefly before then opening up for questions is, it will come up soon. What folks in this world of regulatory reform are calling entity regulation, and Utah is, I would say, the state that's has gone the furthest Utah had gone the furthest. Now Arizona has gone all the way really fast, and we'll see what happens there, and I'll say more about that in a second. But Utah in 2020 created, 2020 created what they're calling a regulatory sandbox, where they're saying, we are going to allow people to apply to come play in this sandbox. We will, if based on their application and their assurance that they can provide, I was going to say risk-free is impossible, but that we will be able to assess the risk of the legal services that they are providing, that we will be able to assess the risk to consumers. We'll loosen different rules. And what I think is really interesting about that, and it's been something that I really hadn't appreciated until I joined the court and started actually thinking about the process of changing the rules and sort of what the implications are of changing any rule. Part of why progress has been slow on some of these things is because states have tended to take the view, okay, we're going to think hard about what we imagine the consequences of changing a rule will be, and then if we imagine that those consequences aren't too bad, we'll change the rule. But if we imagine that those consequences might be bad, then we're not going to change the rule because we don't want bad consequences, and our only option is the rules we have or the new rule that we would change. And what Utah said is actually that's not true. Another possibility would be to say we're not changing the rules across the board, we're just going to see what it would look like if we weren't applying the rules, again, to specific entities, organizations that had gotten permission and that we were aware of so that we could be watching what they're doing. And then we'll actually see what it would look like to change the rules instead of imagining what it might be like to change the rules. So what they, and the reason that, the rules in particular that they're changing really have to do with who can provide legal services and who can put cash into the provision of legal services. So multidisciplinary practice and non-lawyer ownership restrictions are the two big ones that people are talking about when they talk about these reform efforts. And the idea is, the reason they talk about it as entity regulation is that for a long time when we've thought about legal ethics, we've thought of what the ethics rules are doing as regulating the profession. It's regulating us. It's not regulating the practice of law or the provision of legal services. It's regulating us as human beings who are lawyers who are providing legal services. And the idea, and that has meant, okay, we can't have non-lawyers helping pay lawyers' bills because they're not subject to the rules of professional conduct. They won't follow the ethics rules, and they might encourage the lawyer not to follow the ethics rules because they have different motivations. If you stop thinking of regulation as being about the regulation of lawyers and start thinking of it as the regulation of legal services, then you can open up the field of people who can be involved in the provision of legal services. Not necessarily that all of a sudden you're going to have social workers providing legal advice, but you could have a partnership between a social worker and a lawyer where they were equal partners, which currently would be prohibited because it would be the social worker owning a practice that provides legal advice. But you could subject it to regulation and ensure that the services that it was providing whether it was the lawyer or in any way the social worker, presented a risk to consumers or not. And so the idea is we just need to shift the focus a little bit, and we'll see that those rules, like non-lawyer ownership, aren't necessary in order to have a regulated system in terms of provision of legal services. The other thing that opens up is online and AI legal services, because again, if what we're looking at is what are the risks and what are the measures being put in place to mitigate those risks, you can expand who is providing legal services. We are not anywhere near this in Colorado. There are lots of, I will be very interested to see what happens in Utah. And the thing I mentioned about Arizona, so when Arizona established their legal paraprofessional, they also just got rid of Rule 5.4. There is no longer a prohibition on non-lawyer ownership in Arizona. So they're not trying the sandbox. They decided they don't need to wait and see. They're just going to get rid of it, and I suppose they'll see what happens afterwards. You know, the fear that people have, and I think it's a reasonable fear, is that it's not going to be an access to justice focused benefit, that you're not going to see social workers and lawyers coming together to help people who are poor solve their problems. You're going to see what is Pricewaterhouse called now? You're going to see the big five come in and provide legal services, because now you don't have to be a lawyer to own an entity that provides legal services. And that's in California, where a committee had actually proposed shifting away from 5.4. The bar there went crazy, and that was the big fear, was like, this isn't going to help small people, this is going to help big people, and we need to find a way to control that. And I think one of the things that Utah is trying to do is figure out, is there a principled way to help have this be an access to justice tool and not have it just be a money-making tool. I'm not sure what the principled way to do that is, but it will be interesting to watch them try. So that's all I have, but I would love to have a conversation if anyone has thoughts, questions. Yes?
Yeah, why do they talk about only family law cases for Colorado?
That's a great question. So it's a great question, and it's one I already think we're wrong about. And part of why I think we're wrong is because of this listen and learn tour that I was talking about. One of the things that kept coming up in all of the rural jurisdictions that we visited is there are no lawyers here anymore, and there aren't going to be lawyers here, and people need legal advice. And the more times I heard that, the more I thought, oh, really what we ought to be thinking about is licensed paraprofessionals to help in communities like this with a range of things. The reason we started with family law is because that's where there's the most clear need, and I think it felt, so we talked about housing, evictions, but you can't make money representing people in evictions, and we wanted this to be something that someone could potentially make a living doing, and it's just someone who's getting it, that's sort of by definition, when you're in that world, that's just not going to be a money-making possibility. So we looked at family law because there's clearly a lot of need. We think it would be a way that someone could make a living, and we thought it would be easier to carve out sort of what are the kinds of matters that could be easily handled by someone without a license. But as I say, I already can see that I'm thinking down the road, I'm hoping we shift that and rethink it.
What about transactional work?
Yeah.
Like, drafting of contracts, wills. I think that the reason lawyers have kind of priced themselves out of the market is because they've become specialized. I would see as a benefit to the public is if we could get some licensed professionals that were more generous.
I think that's a great idea. Yeah. Thank you. Yeah.
Having practiced in the health law field, I second your concern about the entity regulation or deregulation, because seeing the management companies come in to manage large physician practices and those kinds of things, the physicians essentially become employees.
Right.
And lose the ability to essentially bargain on their behalf for their professionalism, which is a problem, I think, for patients in the long run, other than the fact that there are a lot of really dedicated and ethical doctors who will do the right thing, but from the management perspective, it is not a professional perspective that they bring.
Right.
And one of the things I've thought would be actually really useful in that setting is to require ethics training and CLE type requirements for the managers of those organizations, so that they understand the professionalism that's expected. But there's a lot of money to be made in managing these organizations, and some of them take the income stream and essentially try to make that into a management income stream rather than the professional income stream on which they take a management fee.
Interesting.
Yeah, and that's a very awkward tax situation or SEC situation, but smart people work those things out, don't they?
Yes, they do.
And so in terms of, this would all be under the Colorado Supreme Court in terms of disciplinary actions.
So that is our current thinking. Actually, I should have mentioned that on this committee was Jessica Yates, the Attorney Regulation Counsel. She's working I don't think she herself right now is working on it, but she has folks in her office working specifically on what the regulatory scheme would look like. But I think the thought is that the regulation would be done through that office still.
Would there be any sort of, well, not that we're not required to carry any professional liability insurance, but so I don't know how you would apply that to a licensed paraprofessional.
So that's one of the open questions. I'm sorry, I meant to mention that. That's one of the things we talked a fair amount about. And one of the things that's very interesting is how few lawyers know that you don't have to. So it's, I'm guessing you work, where do you work?
I'm a solo.
Okay,
Yeah.
see, so you know that. It's very funny to talk to lawyers who spent their entire career in big law firms where, of course, they never had to give anything like that a thought because they all assume that
They've
we've
always
all
been
had.
covered.
Yes, and that, of course, you have to. So the number of conversations I've had with people where they'll say, well, obviously, since lawyers have to have insurance, they would have to. I'm like, well, but we did talk about whether, even though lawyers do not have to carry insurance, these folks should have to carry insurance. I tend to be of the view that if we're handling licensing correctly, then just as we don't require malpractice insurance for lawyers, I don't think we should be requiring malpractice insurance. I think it would be another barrier to entry that could be really problematic, but I don't know where we'll land.
Yeah, gosh, as attorneys, I mean, we have the rules of professional conduct. I mean, there are all sorts of guideposts for us in terms of our fiduciary responsibilities. So,
well, there's going to be an entire set of rules of professional conduct for licensed paralegals, and in fact, so one of the things that Kyle will send to you all is the report of the subcommittee, and it goes through. We had a subcommittee that was doing ethics rules, and the recommendation that we came up with were two general principles. The ethics rules for LLPs should specify that they parallel the Colorado rules of professional conduct for lawyers, and that case law and ethics opinions interpreting those rules would provide guidance. So, and then we actually went through in this proposal that, again, you can look at. So for the one series, we went through and talked about which ones we thought would apply to LLPs that we should have written out for them. For the 2 series, the 5 series is a little. Does everyone know what I mean when I'm talking about? But anyway, we went through all of them and looked and said, so there will be a parallel code of professional conduct that will bind the. Again, they have to be licensed, so they could lose their license if they violate them or be subject to discipline. That's another reason why I think since I think that's part of why we don't require malpractice for lawyers, I think if we're doing that well here, it shouldn't be necessary here either. But again, I don't know where we will land on that. Yeah, Evan?
Can you speak a little bit more about Colorado's position on the sandbox idea? You said that was sort of far away or far off. What are the downsides to letting the market kind of try some things, see what works, in an area where 80% of family law litigants don't have any representation?
Why do I think we're far away? And again, this is just one person's view. It's not as if we've talked about this and said we're far away. That has not happened. This is just my impression of where we are. I think that we're very excited about getting this licensed paraprofessional thing done. And there's a strong, I would say, unanimity on my court in favor of getting this done and seeing what this looks like. And more feeling of caution for adding in other things, in part because the people who would have to be involved in doing that work are pretty maxed out. So it has nothing to do with a sense that we don't think it's a good idea. It is literally kind of a, what can we handle right now? It's just, so among other things, we don't want to raise your fees for being lawyers each year. But if we were to start doing more and more of that kind of thing, we probably need to hire more people at OARC, and we would probably need to have a group of people at OARC who, that's what Utah has done. They have a regulator who's watching the entities who are in the sandbox and monitoring them, and so that it would be a financial commitment and a time commitment that would move a lot of other things. And so I've had brief conversations about these ideas with some of my colleagues, and the sort of mood has been, let's see if this works, and then we can try the next thing.
Follow-up question.
Yeah.
When will we know, or how will we know whether this new program works? How long will it take to be able to say this is a good idea, this really helps people, and what are the sort of criteria on which we'll know whether it's successful?
That is an excellent question, and it's one to which I don't have a totally satisfactory answer. I know that part of why we're moving to try to get the pieces in place quickly so that people can start getting education next year is because it's going to take at least a year or two after it's even possible for someone to be licensed this way to see if it's making a difference, right? I mean, that's unfortunately and it's going to take at least a year or two, and some of it will depend on how on the volume of folks interested in doing this. Fortunately, there are quite a number of lawyers who work in small or solo practices who have said they would think that they would be interested in bringing a licensed paraprofessional on into their practice to enable them to represent more clients. So I think there'll be a not insignificant these conversations that we've had, it's just been really gratifying because I think people are excited about it, and I think there will be a pretty significant push to bring people in. That'll be good. But then, and on the flip side of that, there's a really fabulous article by a professor named Elizabeth Chambliss called Marketing Legal Assistance, in which she talks about how those of us who are interested in this access world, we have come up with all these different ideas about what we can do on the supply side, like how can we get more pro bono, and we should have licensed paraprofessionals, but not very much focus on the demand side, and that unless people know about them, unless there's public awareness of these possibilities, they're not going to do anything. And so one of the things I hope we do, Arizona has, if I were using my computer, I would show you that Arizona put like a PSA video that's very, I'll send the link to Kyle to send out too, because it's a PSA video it runs, like they have it running on different YouTube things and stuff. That's basically like, we're going to have licensed paraprofessionals. You know how when you go to the doctor, sometimes you see a doctor, but sometimes you see a nurse. This will be like that. It's all cartoons, and And they started running it for like over a year before there's any possibility that there even will be any licensed paraprofessionals in Arizona, because they're still working on getting that done, because they were hoping that maybe that would start working on the demand side in some way. I have no idea if that will work, but I thought it was an interesting recognition that part of the only way it's going to work is if people know that they want it and if they're looking for it. So we're going to have to think about how to do that. And then I think, how do we know it's working? If we're seeing licensed paraprofessionals helping clients, I'm so embarrassed. I didn't mention the fact that our licensed paraprofessionals can go into court. They will be permitted to go into court. I cannot believe I didn't say that. They will be able to be in court to accompany clients to court and to answer direct questions posed by a judge, but they will not be able to advocate, to start out the argument. So they can answer questions to the client, or they can answer questions from the court and be there to provide emotional advice, but the client would still need to make the argument to the court unless the court had a specific question to direct to the paraprofessional. That's a model that I believe it's Ontario. Ontario has had for quite some time paraprofessionals that can appear in court, and I think that model is from Ontario, and it seems to work well there. So I'm babbling, Evan, because the truth is I don't know exactly how we'll know that it's working, but I think some of it is going to be if we're starting to see paraprofessionals appearing in court with folks who might otherwise have been unrepresented. If we see a decrease in the number of unrepresented folks, but that's going to be something. Coming up with a way to measure success is one of the things that we're still trying to sort through, and unfortunately, because the only example we really have that has had any longevity is Washington State, and I think nobody thinks that was a success, or it had some success, but it wasn't the kind of success people thought it would be. But we think we know why, so we're hoping that these other models like Utah and like ours will have more success. Karen?
I'm curious about the UPL rules that were proposed, and there was a hearing back in February. I had given some comment about unintended consequences in terms of the non-lawyers offering business constraints. So, but no one seemed to really comment on the rest. So what happened with that, and is that what's kind of resulted in what we're doing now, or how's that fit into the progression?
It's totally separate.
Okay.
That's right. I forgot that you had provided a comment on that. So we did some changes. I don't honestly even remember what the changes were to our UPL rules.
In retrospect, since I was focusing on this my own limited thing, I wasn't as concerned about the technician end, because I know that had been well vetted.
Right. I
didn't really focus there. I just wanted to make sure there weren't unintended.
No. So and that was, we had a hearing. I think I'm remembering correctly that in addition to the UPL rules, that also was about licensure, like
attorney regulation.
Yes, the degrees for students who had gotten degrees from other countries. And so we had a hearing where we considered a whole lot of things, but no, that actually is totally independent of this. Was on its own track.
Curious how
No. Yeah.
I'm glad to see this is still moving.
Yeah.
So is there any thought or development of what kind of judicial training will there be to help the court understand how they're supposed to be acting and reacting to these paraprofessionals?
I would say we've started very initial conversations about that. More broadly, I've become, again in part because these listen and learn tours was amazing. One of the things that I heard in several jurisdictions is that attorneys who were providing limited scope representation, the judges were not letting them out of cases, even and that's completely unacceptable. And again, everyone on my court thinks it's completely unacceptable. The rules very, very, very clearly permit limited scope representation, and an attorney has a right to leave at the end of the limited scope representation. So we need to figure out a way to get to judges about that. We've been trying for quite some time to each year at Judicial Conference we have, every year since I've been on the court, we've had presentations about how to work with unrepresented litigants in the courtroom. One of the challenges is that the folks who come to those are often the folks who are really good at working with unrepresented litigants. Like, no, you don't need to be here. Go somewhere else. Bring those other guys in.
Pretty much every CLE.
Yes. So we've been actually thinking, and similarly with plain language orders. A lot of judges have anxiety about plain language orders that, and not only about writing in plain language. They have, I think, they're all lawyers, right? They feel like they don't sound smart if they don't sound complicated. And so I think one of the things we've also been working on is how can we talk to judges about trying to write in plain language. So we're looking at including a session in new baby judge school, which we have every spring, that focuses on all of these things. One of the challenges is so many people come onto the bench really not understanding how much time they're going to spend dealing with unrepresented litigants, imagining that what everything looks like is two lawyers arguing, and so some of it is also education. We've started, the 6 associate justices all sit as ex officio chairs for the nominating commissions, and we've all started encouraging the commissioners to always ask a question about how a judge would deal with unrepresented litigants, and often prefacing it with, 80% of domestic cases in Colorado involve at least one unrepresented litigant. How would you handle that? Just to get people who are joining the bench to realize, okay, this is not what I'm imagining it's going to be. But that is, I think, with respect to our judges, and I think we have amazing judicial officers, but the challenge of there's so much that they needed, that we all, I shouldn't say there's so much that we all need education on, that finding time to get all of it in is really hard. But to me, this is a huge one. Obviously, because I'm here.
Yeah. I mean, I'll be honest, it's concerning. I've been at this for 25 years, and I feel like I'm just getting my feet underneath me. Family law especially is so nuanced, and it involves, families, right? And I understood you to say that this wouldn't extend to contested custody issues or that sort of thing, though that's often where people need the most guidance. I don't know. I mean, I am shocked by the level of competency of attorneys that I see in court quite frequently. I'm shocked by the what I would consider to be skating the edge of ethics that I see from licensed attorneys. And I know for me and a number of my colleagues, a frustration often is what we perceive as, from the judges being a reluctance to sort of rein in bad behavior. I don't know how all of that plays into now expanding and having people who have far less either experience or education or whatnot into an area of law that's very fraught with emotion. And so that's just my commentary. That's not even a question. It's certainly not a resolution or a solution.
I think it's really important. One of my so each of us has liaison responsibilities, and I'm liaison to the Access to Justice Commission. I'm also the liaison to the Standing Committee on Family Issues, and we've been working on a whole bunch of sort of best practices, things including more judicial education for doing trauma-informed work in this area, and it's so clear that we're not doing it well, frankly. And I hear a lot in that context. I hear a lot from the family law bar about their frustration about the fact that in some districts, not all districts, but some districts, domestic is the the lame docket that you get stuck with when you first join the bench. And since most people who are joining the bench are not family law practitioners, it means you've got the least experienced people doing what, a lot of judges, frankly, and I say this as someone who did some family law pro bono before I joined the court. It's frankly offensive to me how so many folks who were DAs and are now judges are like, oh, family law, that's easy. You don't have to know anything to do family law. Like, oh my gosh, you have to know so much to do family law. Yes.
It's quite the opposite.
So I think there is an attitude that's a problem, that then the judges, many judges who are doing domestic are not there voluntarily. They're stuck there for their amount of time. So I think that needs to, we've talked a lot about trying to change that. I've been working with the family law section of the CBA to try to encourage more domestic lawyers to apply for the bench, because I think if we had more lawyers who had domestic relations experience on the bench, maybe we would have people who actually wanted to just keep doing, to be the domestic relations judges, which would be really good.
We have a 2-year rotation. I get older. So, whereas I also practice in Nevada, and their departments are dedicated. So they elect judges, which is wild in and of itself. But so you run. I want to be in this criminal department, or I want to be a family court attorney, and you run for that department, and that's where you stay. So.
Well, one of the things, so I know that lots of jurisdictions have rotations, but I am heartened by Chief Justice Boatwright's example. When he was a trial court judge in the 1st Judicial District, he ended up being the juvenile judge for 9 years, even though they also have rotations, because he said to his chief, you know what, just keep me here, I'll do it. And nobody else wants to do it. And he was really good at it. So I think that, I look at someone like Mary Moses, who's a new judge in the 2nd JD in Denver, and she was a family law practitioner. I don't know what she'll decide to do, but she and I have talked about, she may ask if she could just do DR, and that I think would be great. And there are judges there who get stuck in DR who don't want to do it. So I think we don't have to, just because we've been doing it this way doesn't mean we have to do it this way. It's sort of my hope. But yes, I definitely recognize in anything we add into family law, we need to recognize what a complex area that is already, and we need to think about the consequences.
Okay. Just a quick follow-up question. You mentioned trauma-informed representation, and has that had an influence on the limited licensed, I don't know what we call it initially.
LLP, yeah.
Jim Coyle was talking about limited licensed technicians,
Yeah.
so I'm a little confused where we are, but the idea that there's a whole other reason that people need someone with them in the courtroom, which is just, it's a traumatic experience, even if no one had anything else.
Right, just the fact of being in court, right.
Yeah, and I don't know how you mix that in, and I don't have any suggestions on that, but I was just curious, since you used a sophisticated phrase, trauma-informed.
Right.
I just wondered how that theme is played.
Well, I think yes, it did play a role. It's why we decided that we had a lot of debate about whether LLPs should be able to go into court with the client, because that's the place where people have anxiety about it, right? But we decided it really was one of the most valuable things that they could do, because just being there for support, even if they couldn't make arguments to the court, if they could just be there for support, that actually could be the most helpful thing they could do. So I would say, yeah, definitely was a part of the conversation.
Can you explain what that looks like? They can't make arguments to the court. Is that? It's just a little confusing to me how that would actually work. Like you've got this person who's like helped you, guide you through this entire process and knows how it works. And then the judge is going to ask the litigants to argue why they should have so much money. Yeah, like that's the like, and I guess that's what they're gonna fight about is like the money and the assets if they can't do custody things. I just am, I'm not a family law person, obviously, so I don't know really how it works normally.
Right. So I guess think the answer to your question is yes. That the idea would be that you could come with your client, you could sit up at the table with your client. Again, you could answer questions from your client. You could say this is the thing you want to present now. But you would not be standing up at the podium and arguing to the court about anything in particular, or standing up at your table and making arguments. That the party would need to make the presentation to the court.
And questioning witnesses and that sort of thing.
Yeah.
And why? Why? Like, I can see like the concerns, but to me, it's like if you're going to have all this training, why can't they do more?
So all of this, I think, is about is drawing lines where we think that people will feel like, well, now this is just a lawyer. So trying to make trying to distinguish the registered nurse from the doctor. What are the things that registered nurses can do a lot of things, a lot of things, and we may be being too cautious here because this is new. I imagine that for example, being more general transactional work, I think that's such a good idea. I imagine this changing over time. But right now it's kind of, what are the things we can say, this is what distinguishes an LLP from a lawyer. This is one of them. It's been really helpful that this is a multi-generational group that's been working on this, because for people who are, I'm sort of in the middle generation here, for people who are a little bit older than me, like this idea of crossing the bar. You can only cross the bar to speak to the court if you're a lawyer. So that doesn't resonate with me quite the same, but it really does. And so I think that felt like a line that, in order to get support for it, was going to be necessary to draw.
Because I could see like you're not allowed to talk in court. That's like a clear deadline. But then if the judge can ask questions, I just feel like it's going to get so messy and blurry. That was just my reaction.
Yeah. Well, and keep in mind that right now, everything I've just said to you is what this committee proposed to the court, and the court said, go forth and make rules to present to us. The court hasn't approved any of the rules. The court could look at this in when we're really getting into the nitty-gritty and approving the rules of professional conduct and say, well, now wait a second. Actually, we're not comfortable with this, even though the committee was comfortable with it. We're drawing a line here. This will, once all of these rules come to us in rule form, just like what Karen and I were talking about before, it'll go out for public comment in a hearing, and I am sure we will hear a lot. So we're much of the way there, but we're not all of the way there by any means. I think we're supposed to have a happy hour. I'm happy to just stay here and keep talking, but I also feel like I'm sort of trapped. I've trapped you all here.
Everybody just come over, help yourself. We've got some